Okay, good morning and welcome to this meeting of the Licensing Subcommittee. Present today we have myself, Councillor Mike Bland, Chair of the panel, along with Councillors Andrew Harvey and Liz Harvey, who are panel members, and Councillor KG Moses, who is our reserve member this morning. Also in attendance are Anton Walden, Licensing Officer, Peter Key, Legal Advisor, and Andrea James, Democratic Services Officer. There is no fire alarm planned for this morning. Should the alarm sound, please leave via the nearest available emergency exit, basically through the double doors at the back or through the side door behind the glass panels. For guidance on making your own recordings of this hearing, please see the notices in the agenda this morning. For this meeting. I can confirm that this meeting is being minuted and audio recorded for the Council's website. So we'll follow the agenda. First item, apologies for absence. Andrea, do we have any apologies?
There are no apologies.
Second item, substitute councillors. Andrea, do we have any substitute councillors?
We have no substitutes.
Third item, declaration of interests. Andrea, have any declarations been received in advance?
None in advance, Chair.
Are there any further declarations from the panel?
Nothing, Chair.
Nothing, Chair.
And nothing from me either, so no further declarations. Now, the order of business will follow page 5 on the agenda, and that will be followed through the meeting. Basically, we'll be looking at one premises licence application. The licensing officer will introduce the application. The applicant will then be able to make the application. The applicants can then be questioned by the panel or by other responsible authorities or by our legal officer as well. After the applicant's made the application, I'll be inviting responsible authorities to speak. Again, the responsible authorities could be asked questions by the panel, and the same procedure applies there. Other persons would be allowed to speak after that. There are no other persons, so we won't be dealing with that today. And after that process has finished, the applicant has the right to summarise the application. And following that, the subcommittee will retire to consider the decision. Okay, so that's the process. So item 5, this is under the Licensing Act 2003, application for a premises licence for Alamus Cafe, 23 Lower Bridge Street, Canterbury, CT1 2LG. So, Mr. Walden, can you introduce the application?
Good morning, Chair. This is an application in accordance with Section 17 of the Licensing Act 2003 for a premises licence. The premises is Amelia's Cafe, and I can advise the meeting that before this meeting commenced, councillors and officers attended the premises to conduct a site visit. I can confirm that there were no discussions as to the merits of the application. The only points of clarification were where CCTV would be, or perhaps a bar, etc. The application has been updated as to the activities and hours sought, and that is detailed on page 28 of the report. And I can advise that Councillor Dixie, who was an objector on the basis of hours, has withdrawn his objection due to that update in hours. There are a few points of clarification. I'm sure that will come up through the amended conditions and hours, but unless you have any questions at this stage, sir, that is the application and report.
Thank you very much for that summary. This is the point at which I'll ask Mr. Bartlett on behalf of Mrs. Parger, if I pronounce that correctly, to make the application. Mr. Bartlett.
Mr. Chairman, the application is before you, as it is on the forms. We have agreed certain conditions with the police, which is why they're not here. Restriction to 20 events per year. And if necessary, that can be reviewed with the police and the licensing officers, if that's deemed either excessive or not enough. The CCTV system will be maintained in good and efficient working order. And as I said, when we were discussing the CCTV in the cafe, police come down with a flash drive and they are more than happy within 24 hours to take recordings. The system records for 30 days. So it gives the police some leeway of coming in there and getting the necessary systems off there if there ever is an incident. The staff are going to receive training in the Licensing Act. I have plagiarised a Staffordshire Trading Standards training package, which seemed to me to be the best one that was available. We will keep a record of that training. At present, it's intended that that will be on an Excel spreadsheet so that we can keep everything in the same place. Refusal register will be on one sheet. Training log will be on another sheet, and an incident log will be on another sheet. That way they're all in one place. There's no books wandering around, getting lost or what have you. And again, the training will be given on what to do with regards to Challenge 25, which we will be operating, and how to do the training. Training will be repeated every 6 months, and the staff will be required to show to the pargers that they are up to speed with the training package that we will put in place. It had been suggested that SIA doormen be there all the time whenever there was an event, let's call it. We think for the size of the premises and the frequency of the event, SIA doorman at every event is over the top. Most of these events are going to be something like a leaving party for somebody from an office, or perhaps a birthday party, or a cultural event, which is what we originally was the original planning. Those cultural events, gentleman in the premises today was an Albanian. He might want an Albanian evening. The parties are Greek. They might want to promote the Greek culture. So what we have suggested is that each event will be risk assessed to see whether it presents the possibility of conflict. If it does, then the parties will get in SIA door supervisors. If it doesn't, staff will monitor it. I have to say, from my short acquaintance with Mrs. Parger, I don't think I'd go against her if you told me to get out of the premises. She's a strong lady. As I say, Challenge 25 will be implemented. We will be looking for identification by way of passport, photo ID, driving licence, or the ones that the young people get now, the pass cards. So it's not going to be a case of how old are you? Oh, I'm 18. It will be, right, okay, prove it. And then, as we have said, we've made the offer of reducing the hours. We don't understand the thinking that this is going to be a bar, because having looked at the premises, you will clearly see that it doesn't lend itself with being a vertical drinking establishment. But it will, you know, businesses have got to make a profit. And if by putting events on, we keep the business going, then that's it. The downside of that, of course, is if we give them carte blanche then there is a temptation to go over the limit. We don't want that. This is a really nice little cafe. This is the type of place I would take my 94-year-old mum to. You know, and I have to say there's not many of them in Canterbury that I would do that to with the same confidence. So that's the actual application before you. We understand the Crime and Disorder Act and the Prevention of Crimes Act, and we cannot see how granting this licence, subject to the mandatory conditions and the conditions that we've offered, will in any way adversely affect the licensing objectives. Now, I know we have 800 premises in Canterbury City area. It's a university town, or two university towns. But in the absence of a cumulative impact policy, the presumption in the Licensing Act is to grant subject to conditions that will promote the licensing objective. And we would quite simply say that we've done that. We've gone as far as is reasonably possible whilst making the business viable. So the application is before you, Mr. Chairman.
Okay, thank you very much for putting the application. Now's the opportunity for members of the panel to ask some questions of you. So I'll kick off, and then after that I'll ask my colleagues if they've got some questions too. So basically you're saying this is going to be for 20 events a year, yes?
A maximum of 20 events a year.
So that means that alcohol will only be sold at these 20 events a year?
No, alcohol will be sold in the premises normally. We've got the problem of the first section of the licence. As I said in the cafe, if wine is stored in a glass-fronted cooler, under the Act, it is deemed to be offered for sale. Now, the 182 guidance refers mainly to supermarkets and the like, where alcohol is being taken off premises. But we say that that actually applies here, because if it's being offered for sale, even if it's not sold, an offence is committed if it's outside of the licence. And that first section is purely for the avoidance of making the parties liable for that offence.
Okay. Let me, just to clarify in my own mind, because I need a bit of clarification here.
So do I, sir.
So basically, the 20 events applies to cultural events or birthday parties?
Yeah, the event normal working hours for the parties are between 0700 and 1900.
Yeah.
Alcohol could, in theory, be sold all the way through that. If it is sold, from the clientele that's gone in there, it's mums with children and what have you, who meet up for a cake and perhaps a glass of wine. For the cultural events, the additional hours will apply. And then that is your 20 events of the year. So alcohol may be sold outside of, I would call them the core hours. Apparently that causes confusion. The normal operating hours. So 0700 to 1900, normal alcohol sales. 20 events in the evenings. And personally, and I was discussing this with Mrs. Pardew this morning, in the first year, I doubt very much if we'll hit 20 events. Does that help, sir?
Yes, it does. So let's just concentrate on the events for the moment. So what are the hours for the 20 events?
We have agreed with the amended conditions, the licence will be in effect 0700 to 2300 and 0700 to 23:30 Friday, Saturday. But the evening period will only take effect if an event is on. The core hour would finish at 1900.
Okay. Okay.
It's common in my
Yeah,
in my time.
So, were we to grant these hours, you would be able to sell alcohol from 7 o'clock in the morning to 7 o'clock in the evening. Is that right?
Yes, technically, yeah.
Technically. Well, technically, generally speaking, means if you've got the possibility of doing it,
Yeah.
it occurs.
It's whether or not if people want alcohol normally that early in the morning, they will go across the road, buy a pint of bitter for £3.50 and a house double for £1.99.
Okay. Then 20 times a year, up to 20 times a year, after 7 o'clock in the evening, you may be selling alcohol up to
Up to 2300 Sunday to Thursday, 2330 at Friday and Saturday, and that's broadly in line with the core hours within the licensing policy.
And at what time do the 20 events finish? When are people expected to leave?
Well, I would say that it'd be 23:30 Sunday to Thursday and midnight Friday, Saturday. That gives them half an hour drinking up time.
Okay, all right. Okay, that helps me clarify in my mind. Okay, so as far as I'm aware, there aren't any residents in the proximity of the cafe, are there? There's no residential housing.
There are
There's a
residents.
couple round Church Street, St Paul's, I think.
You probably know more about the names of the city streets than I do, sir, because I come from Ashford.
Yeah.
There are residents behind, but they would not, I would suggest, be greatly affected by any event in Amerlis.
Okay,
There are no actual windows to the rear of the premises,
right.
so I don't think the residents will be adversely affected.
So there's a row of I think that's Monastery Street, if I'm right at the back.
I will believe you, sir.
the ones that you're saying are behind.
Yep.
I mean, they're at some distance, aren't they?
Yes,
I
they
mean,
are. There's a car park between the
Yes.
back of the building and the residence, and then obviously gardens as well, albeit they're relatively small.
Yes. So, I mean, how many people do you imagine will be coming to these cultural events and birthday parties?
There are 42 covers within the cafe. I would not think that if we put another 50% on there, I think that would be getting close to reaching a safe capacity.
Okay.
For there. Obviously, the fire brigade, who normally work out these capacities, haven't made a representation.
Okay.
So I normally rely on them to set the capacity under the fire safety regs.
Right. So there's going to be the playing of Greek music or Albanian music and maybe some dancing?
Yes, perhaps. What we envisaged was the area where I was sitting when you came in, which is, I think it's got an off licence or a small convenience store next door. That would be where the music is. The reason for that is it would tend to go back into the cafe, and that would attenuate some of the noise.
Okay. All right. Okay. I think that's all the questions I have at the moment. So, Councillor Harvey?
Yeah, just one. Can I just confirm it is just wine you'll be selling?
At the
on
moment, the
premises?
intention is just to serve wine or perhaps a cocktail, not shots or anything like that.
No.
And no beer, no draft beer. There is no intention to serve draft beer, which, if it was going to be a bar, would be, something that people would want.
Okay, thank you.
Okay. Other Councillor Harvey?
I had the same question, so that's covered it. Thank you. Thank you.
Okay. Any questions, Mr. Key? Yeah.
Is this working? Yes, good. So, bear with me. So that there are just need to be clear what the hours are. for various things. And just to open by saying we need to know the opening hours proposed, standard and non-standard, and then off-licence, on-licence hours, dance, performance of something like dance, 2 separate sets of hours, recorded music and live music. So all of these, I have to say I'm unclear what the hours are.
Normal operating times, 0700 to 1900. And that is only, as I say, because of the displaying for sale.
And when you say operating, do you mean retail sale of alcohol?
Yes.
And
all of the
opening?
licensing activities.
And, right.
Well, let's keep it simple. This is my thinking. If everything is on the same hours, then it's simple for the owners to know what they're doing and to keep it in track. If we overcomplicate things, we've got more chance of things going wrong, and that is not what we want.
So in terms of licensable activities, the standard hours for all the activities that you're applying for, live music, recorded music, dance, performance of dance, retail sale of alcohol, are 7 in the morning to 7 p.m.
Yes. Whether they
Standard.
would ever be used is a totally different matter.
And what's the opening and closing times?
They will be half an hour after the licensable activities cease.
And then the non-standard timings, the 20 events per year for recorded music, live music.
Keep everything simple. Keep all licensing activities at the same times, and that will be, as I've said, 0700 to 2300 Sunday to Thursday, 0700 to 23:30 Friday and Saturday with a 30-minute drinking up period. I'm still old enough to remember 68 Act when we
Right.
had 20 minutes.
So the council's statement of licensing policy gives core hours, and the core hours, I think, start at 10, so 3 hours later than what you're asking for.
Yes.
And I hear what you say about alcohol being displayed, but that could be curtained off, couldn't it? Or a screen could come down the front of it.
It could be removed, but then again, the Act is meant to make it easy for the premises licence holder. It actually says in the Act and in the 182 guidance that conditions should not be onerous, and we would say that putting conditions that are basically basically there for the core hours.
This isn't necessarily a condition. It's a question of the hours.
Yeah.
And is it onerous to have a screen to pull down to indicate that alcohol isn't for sale until 10 in the morning?
Well, I as I say, under the 182 guidance, the guidance suggests that the hours should match the normal operating hours of the premises. We for some reason, we seem to be forgetting the 182 guidance.
Could you direct, I've got it open on screen, if you can direct me to the
I
paragraph.
believe, and this is off the top of my head, it's paragraph 15.1. But as I say, that is off the top of my head. Let me see if I can...
15.1 is licence fees.
No, that's obviously not the one. Off the top of my head, I can't quite remember it, but there is that. In fact, I believe it's referred to in the licensing officer's report, the paragraph concerned.
Right. Do you mean in the officer report of the officer sitting next to me?
No, I mean Miss Genevers.
Oh, all right. Well, perhaps I'll leave that bit to her. But where there's a departure from the core hours policy, which is to start at 10, the committee might wonder what reason is put forward to depart from the core hours.
Well, I would suggest that we've already done that. It's purely to allow the free running of the premises and not have to worry about either curtaining off or taking the stuff away. You know, if it's displayed, then it must be licensed. And with the greatest respect, I don't see, if you're going to condition that because of the hours that are brought in by your core hours in the licensing policy, you know, you are effectively, you have to show how that is going to adversely affect the licensing objectives. You haven't got a cognitive impact policy. And the essence of that, Mr. Chairman, is if there was a special policy on the cognitive impact, I would have to sit here and I would have to make the case for any licence at all. Because the assumption would be that you will refuse a licence unless I can make a case otherwise. That doesn't apply here. Anton refers to legal advice that has been given, but my quick perusal of the documents don't show what that advice is. You're asking me to accept, and I trust Anton, we've known each other a very long time, but you're asking me to accept that licence, that advice is properly given.
So which advice are you referring to?
Sorry?
Which advice are you referring to?
It's referred to on page 11 of Anton's report. What we would say is that advice, and I know from personal experience that when I put in for a legal opinion, I put in and I say, this is the points I want you to comment on.
I'm sorry, which passage on page 11 of the report?
About 3 paragraphs down. There's a comment from Anton that we have got it just about right.
I think, if I understand, there was a case that came before the district judge some years back in which he looked at the policy and said that, and commented in his judgment in relation to a completely different premises, that he thought that the judge thought that Canterbury had got the balance about right. But
Well,
could I just clarify?
Can I just say something? If that is the case, then in the rules of natural justice, that case should be referred to so that I, the applicants, and our consulting solicitors can review it. Otherwise, it's unconscious bias.
But I don't think you've raised this in advance. You've seen the report. Could I go back to the...
I haven't seen the report.
Anton's
We
report.
mentioned this before the hearing. Nonetheless, I've had a quick scan of the report. And but the point I make is that if you're going to refer to a stated case or a legally provided opinion, it's right that the person who's making the application should be given an opportunity to review that case, if necessary, obtain their own legal advice, and then decide one way or the other.
All right. Could I bring you back to this point that the policy says core hours start at 10?
Yes.
And the general provision in the whole of public law is that if an applicant is seeking to depart from policy, the applicant should offer a reason, if they want to,
And have we
for
not done
departing from policy. And did I understand you earlier saying that we, the committee, have to give a reason for the policy?
No, not for the policy, good God. The policy is a democratic document which the committee, the full licence committee, approve. But individual conditions such as curtaining off a chiller, there has to be, under the Human Rights Act, justifiability, authorisation, proportionality, audibleness and necessary. Now, if we're not going to, there is going to, the chances of selling alcohol at that time of the morning is minimal, and I think we have to accept that it is minimal, then it's difficult to see how a policy, how a condition meets those Human Rights Act demands.
So just to be clear, you think that if a licence holder had to pull a screen down, like supermarkets do sometimes, that might be a breach of her human rights?
I'm saying that the Human Rights Act sits alongside all legislation, and that being the case, it must have regard to when making any conditions. I'm not saying anything about people's human rights being affected. What I'm saying is that the legislation is such that those factors have to be taken into account. Christ, I've been enforcing law for 50 years, Mr. Chairman.
So could I just go back to the core hours, because the opening hours, core hours, for the retail sale of alcohol or all licensable activities, 7 till 7 p.m, and then
The 20 events.
Monday to Thursday for the 20 events, 11 p.m. and 11:30, closing half an hour later. Just to check about off-licence sales, because they were treated differently.
The only off-licence sale, and again, it's a new mute point within the law. The area outside the front of the premises, there are 4 tables?
Yeah.
There are 4 tables. Technically speaking, if drink is taken out there and bought out there, it's an off sale. And that merely takes that into account. We're not looking for people to come in, buy a bottle of wine and go.
So just to check, what are the off-licence hours?
The same as all the others.
Okay, thank you. Then if I could just take you to page 33 of the report. I wasn't sure whether those were hours agreed with the police, conditions agreed with the police.
Which conditions?
On page 33.
Oh, yeah, you're going to have to help me because
I don't know if, is there a report pack spare or?
Yes, there is.
Yes, I've got that now, yeah.
Cultural events permitted under this licence, 20 a year. That's the non-standard timings, is it?
That's correct.
So that's in paragraph 2. Thank you. And then paragraph 3, the CCTV system shall be provided on lawful request. What does lawful request mean, and when must it be provided?
Well, we have accepted, well, it says, we were available 24 hours or by prior appointment. Lawful request would be, and it's what was originally in the application, trading standards officer, authorised police officer or authorised member of the council. That's a fairly standard condition.
I see that it says a member of staff shall be available within 24 hours, but what about the provision of the CCTV? When does that have to be provided?
Whenever the police want to get it. If they come down with, as I've said earlier, if they come down with a flash drive, they can have it then.
Thank you. Or immediately on request?
Yeah. But what I would say, it's not unusual in my experience to ring up and say, have you got any recording of this incident? Now, where does request come? Because if it's over the telephone, then that's the immediate request. If it's when the police officer arrives, then that's fine.
The paragraph 5, the logbook shall be kept. I can't see something about who might be able to inspect that logbook.
That's the same as with the CCTV.
And then paragraph 6 has off sales finishing earlier. Is that changed now to match what you said earlier about
No,
hours?
well, the off sales, the payment licence is for, just let me,
$77, you mean?
yeah, the outside payment licence, 7 to 7?
7.
Yeah, the outside payment licence is for 7 to 7, so tables have to come in.
So when do off sales have to finish?
When the tables come in.
Which is
Because
7 p.m.
Yeah, because as I've said, the only reason for having the off sales is to allow people to drink at the front of the premises.
So if the committee decided to,
We've got no problem if the committee want to restrict the hours on the sale for the front
off sales
of the premises.
to 7 p.m.
Yeah.
And then condition 8, hot food and cold food shall be available until 11 daily. That isn't a...
It's not a licensable activity.
No. So is
So
that
not
condition
conditional.
appropriate?
Yeah, that was my fault. I was in error when I put the blue notice up and I didn't include late night refreshment.
Thank you very much for answering my questions. I'm grateful.
Okay, any questions, Mr. Waldron?
Please, sir, I've got a number of points for clarification. Firstly, the Human Rights Act is obviously, firstly, it doesn't just apply to individuals, it applies to the community as
Of
a whole.
course.
And the licensing authority has a duty to make that balance.
As I've said, that we fully accept that.
The Human Rights Act is automatically incorporated into the Licensing Act. So since its adoption, every act that took place afterwards, you'll find a certification that it is human rights compliant.
Are we asking questions or making statements?
Well, I'm just coming on to why I'm going to ask you these questions.
Fine.
Because you've raised the point of human rights. It's to make sure you know why I'm asking them. Firstly, at the visit this morning, we were told there's no bar.
That's right.
On the plan, it is shown there is a bar.
It's a bar that is being used at the present for food and coffee. It's not being used for alcohol because we haven't got a licence and there's no intention that it is used for alcohol. It will be waitress service.
I understand that. I'm asking for clarity because most people, lay people, would think a bar is a place where you get alcohol from. And you're dealing today, and some of your representations, it is not our intention to sell draft bitter.
No.
It is not our intention to sell alcohol, but other than wine, but now we might be dealing with cocktails. So you'll be having spirits. What the licensing authority must have before it is clarity as to what they are granting. Now, you are a very experienced licensing representative, and if it's granted, do you accept in the terms you've putting aside the hours, whatever they are, that if it's granted, as per the application, your client will be able to sell wines, spirits and beer?
Yes, I do.
So the committee have to be certain sure that if they grant it, they know what they're granting. Because Canterbury has learnt the hard way that many businesses, and they are genuine intentions, they intend to operate in a certain way, but they do have to be viable. And sometimes that viability means they have to adjust their business. So do you accept that if it is granted without certain provisions in place, that premises could become a stand-up bar?
No.
It couldn't.
No. It doesn't have the capacity or the intention of the management to turn it into a bar. Let me finish first. A bar, in law, is the place with the sale of alcohol takes place. The rest of the premises is not a bar. And there's case law on it from a long time ago. So a bar is where if I come up to you as the owner and I say, I'll have a glass of wine, please. I pay for it. You give it to me. That is a bar. I go away and I sit down and I drink it, bearing in mind that consumption is not a licensable activity. That's not a bar. We all accept this. We refer to premises as bars. But the bar is the place where the purchase takes place, not the rest of the premises.
But the license sought is for consumption on the premises, is it not?
That is.
Yes.
But, as I say again, we both know consumption is not a licensable activity.
Agreed. On the visit this morning, we saw where the tables and chairs are placed.
Yep.
Where is the dancing going to take place?
It may be that when the dancing takes place, the 3 tables closest to the door will be moved. It's still going to be taking place within the licensed area.
I'm not disputing that. I'm just,
No, I'm trying to clarify, make it easier.
and in the same way tables and chairs can be taken out, they can be taken out right through the whole premises, can't they, if they wanted
It's
to?
possible, yeah. But if that was to be the case, then that would be the ideal time for a review, which is open to responsible authorities or members of the public.
Is it something that your client would consider that all tables and chairs must be in place when alcohol is being sold?
I think that would be impractical if they're going to be doing Greek dancing or
I'm saying, you didn't let me finish, apart from the 3 tables you've identified at the front when dancing is taking place.
no, the tables out the front are subject to the payment licence.
No, you mentioned that the tables inside at the front would be where the dancing is.
Yeah, that's what I anticipate.
So I'm saying to you,
But it may, if I can just finish, it may be that it would be more practical, and I don't know, we'll find out by trial and error, that in order to attenuate the noise, the rear of the premises actually is better. You know, we're trying to actually promote the licensing objectives, and one of those is nuisance. Now, if it turns out that people dancing, doing Zorba's dance, for instance, and you've got a line of people and they're doing that, then it may be that it's better to be at the back of the bar. But I think it's quite improper that the owners be allowed to risk assess that noise. In trying to promote the licensing objective, they should be allowed to risk assess it, and if it's better to move the noise away from the windows, so be it.
and one final question. You've mentioned that in number 2 on the conditions that you propose, cultural events permitted under this licence shall be restricted to 20 events for the first 12 months, and if necessary, in conjunction with the police and licensing authority at the end of the period.
Yeah.
Now, you've already stated that conditions have to be fair, reasonable,
Yes.
proportionate.
I know, and
What does that mean at the end of 12 months? Because as long as there is a review with the police, it doesn't stop the activity if people are unhappy with it. It just means that a review has to be conducted. Doesn't have to say what the outcome of the review or...
no, what we're looking at is the 20 cultural events. If, in conjunction with the police licensing officer and the licensing, oh, excuse me, I don't suppose you drink of water, is it? Oh, thank you so much. If, after the 12 months, the police licensing officer, the council licensing officer get together with the parties and they discuss it and make a decision as to whether the 20 events condition is actually viable, or whether it still needs to be kept in place, or whether it can be removed.
But they've got no authority to remove that, have they? Even if they agreed, it is a decision of the licensing committee if that condition
Quite
is
right,
put on there.
it would need a minor variation, or a full variation.
The point I'm making is your point, is that conditions have to be transparent, enforceable, and this isn't. So is there wording?
I don't see how it's not.
Well, as a lawyer, I read that and I see that all I have to do is conduct a review. The council licensing enforcer may say, I don't want this to continue. The licensor will say, well, we've had our review. I can continue. If you do not like it, call a review.
Now I'm trying to, this is meant to be a condition where, not a condition, sorry, a process where we consult. It's actually there is case law that says that that must be the case. I think if you look it up, you'll find it's off the top of my head. So don't take this as gospel, but I think it's the Crown against the Chief Constable of Sussex.
I've no further questions, sir.
If I can just answer the question. The idea is that at the end of the 12 months, the licensing officer, police licensing officer, get together and sit with the licensee and says, has this worked? If it has worked, then a decision is made as to whether to seek a minor variation. That brings it back into the field of the licensing authority. The people who have the ultimate say is the licensing authority, or under delegated powers, the licensing department. What we're not saying is the police and licensing authority can get together with the parties and say, yeah, it's gone cracking. Let's get rid of that condition. That would clearly be wrong. What we are saying is that if it works, then it is open and only open to make a variation. And it would still revert to yourselves to make a decision.
Yes, Mr. King. Yeah, please.
So I just want to check, after 12 months, there is no right to hold any further cultural events of these 20 type events. So if there is a delay in the police and the licensing officer enforcement meeting, and if there's a delay in the variation process, there can't be any more of these. This is a time-limited 20 events for the first 12 months and no right at all to hold these non-standard hours or cultural events, same thing, after 12 months.
I would look at it in a different way. I would say that after 12 months, the condition fails.
I missed what you said. After 12 months, what happens?
The condition would fail.
Condition fails.
This has been agreed with the police to give the police time to assess whether or not the premises are being run properly. Therefore, if the premises are being run properly, either the police request that the condition continue for another 12 months, or the police say we don't need it, in which case we would seek variation from yourselves.
But how does that work under the Act? Because the licence granted now is fixed in stone. It can be...
Say again.
The licence terms and conditions granted now are fixed.
Yes.
They can't be varied other than through the variation process.
Correct.
Or on review. If the police think that, or the licensing officer thinks that it should continue to be just 20 a year, how can that be given effect to?
Well, and if necessary, reviewed. So it would continue ad infinitum if the police didn't agree to a variation. If the 20 events would be carried over for each new year.
But it says for the first 12 months. If you
Yes.
mean for every 12-month period,
Yes.
so it's not for the first 12 months, it's for every 12-month period.
Well, that's how I understand it, bearing in mind that these are the police's conditions. And the police are not here because they feel that they are adequate.
Okay, but but basically you're agreeing that it's for every 12-month period, not
Yes.
just for the first.
That's the way I view it, yes.
Right.
And as I say, unfortunately, without the police, we can't clarify that.
I've just got one more question from my colleague here,
Yes.
and one more comment from me, and then it's the opportunity for Mrs. Geneva to ask questions as well.
Yeah.
Okay.
Yeah, how will you monitor the noise level of the music?
Well, this is a problem. The people who actually have the training and the experience to comment on the noise level haven't made a representation. The EPOs haven't put in any representation at all. So the only conclusion that can be drawn from that is that they don't think that the licensing objective will be compromised by the noise. We could get a noise monitor in. They're relatively cheap. My experience from working at Dover is that they are horrendously inaccurate, and that in order to properly monitor noise, you need a tripod, you need the proper kit, it needs to be set up a set distance away from the origins of the noise. Now, that being the case, and as I say, EPO haven't made a representation. So we could monitor the noise. I think it's common sense, to be quite truthful. The Pargers don't want a raucous cafe. They want to make money, just get on with it. In the absence of a representation by the EPO, it's difficult to see how we can condition it.
Yeah, it was more, I should have made myself clear really, it was more for the 20 events.
Oh, well, I understand that, Mark.
You know, obviously during the day the cafe wouldn't
No,
be
but
blasting out music because that wouldn't be.
I have to say from experience, the easiest way to monitor such things is for somebody to go outside and walk round. And if they can hear any significant amount of noise from outside the premises, they come in and they turn it down. You know, it's common sense, I suppose. In places that are going to have regular events, they install quite expensive noise controllers in the ceiling. And when it reaches a certain level, it cuts off the amplification, if there is any. I've never heard of amplification with Greek music or anything like that. But that will do it. But with 20 events a year, whether that would be justified, I'm not really sure.
Thank you.
Okay, I just wanted to make a comment about this period between 7 o'clock and 10 o'clock in the morning. And I mean, you made a comment that the chances of alcohol being sold then are minimal, but this subcommittee's got to consider even a minimal chance of alcohol being sold outside of the core hours policy. And I have to say, I can think of some characters who may wish to take advantage of buying alcohol at 7 o'clock in the morning. And that would be a concern, particularly if the owners of the cafe didn't particularly wish to sell that alcohol. So that is a bit of an issue for us, which maybe
I understand,
we can think
Mr.
about.
Chairman. As I said to you earlier, there is the snooker club round the corner. I don't know what time.
It's on. We'll be okay.
There's a snooker club around the corner. There's a Thomas Ingleby opposite. The type of person that wants a glass of wine at 7 o'clock in the morning is not going to come to Amelis. It's
Well-
going to go, it's going to go, well, as I say, using an element of what I would call common sense. I understand your concerns, don't get me wrong, but let's use an element of common sense. Do I go into Amelis and pay £7 a glass for a glass of wine, or do I walk 25 metres across the road and get, for a fiver, a pint and a house double? That's the type of people that we're talking about. And it's a matter of common sense that they're going to go across the road. And good luck to them, because they won't be affecting the premises that I'm representing.
Well, I don't disagree with you about the ordinary use of the term common sense, but I have to say some people's common sense varies from one to another person.
I can assure you
and,
after 50
and
years
it
of-
is our responsibility to take this into account.
I can assure you after 50 years of law enforcement, I'm aware of the differences in common sense.
I'm sure you are as well, because I have
I understand what
I
you're
have
saying.
similarly had experience in criminal justice, shall we say.
Yeah.
Okay, I'm going to finish my comments there. This is the opportunity for Mrs. Jennifer to raise questions as the licensing responsible authority. Mrs. Jennifer.
Good morning and thank you. My name is Sue Geneva. I'm a Licence and Enforcement Officer with Canterbury City Council, and this is my colleague Diane Attenborough. I have attended the premises to assess the application, and excuse me, when I attended, I met the applicant, Edmund Parger. He's applied for this application as an individual rather than, say, a company. So I have met Edmund, and he is the proposed DPS. That's the designated premises supervisor. That's the person who will have sort of day-to-day control of the premises. Now, forgive me if this has already been discussed, but I do note that he's not here today. So I would like to ask Irina, who is Edmund's wife, is there a reason why Edmund isn't here today? Is he elsewhere? Is he unwell?
Somebody need to be at the shop, and it's just my husband and my sister. The shop can work just with 2 persons, need more. Unfortunately, I have to be here. Somebody for us have to be here, and I chose to be here.
It's understandable that the licensing officer should wish the applicant to be here. But as I said to you in the premises, Edmund's first language is Greek. He's getting better with English, but Irina is much more knowledgeable in English and can answer the questions more clearly. And also, of course, as Irina said, somebody's got to look after the shop.
Yeah, that seems to be the explanation, so do continue with your question.
So, accepting that Edmund isn't here, but we have got Irina, who knows the premises very well, and we have met before. I would like to ask you, so let's say it's a Friday or a Saturday evening at the premises, and there's no cultural event. There is no event taking place. What time will alcohol stop on a Friday or Saturday?
Can you ask, please?
Mr. Chairman, I think we've already answered that. If there's no event on, it will finish at 1900 hours.
I directed the question to Irina. Is there any reason why she couldn't answer?
With respect, Mr. Chairman, I'm the rep, and it's my job to represent Irina's view. I understand that Irina doesn't understand the legality of the terms, and that can cause confusion, which is why I'm here.
Okay, can you answer the question then? I mean, that would be simple.
Well, I think we already have. That if there's no event on it, the premises will close at the normal time, 1900 hours.
Is that clear enough?
Why are we at this situation that we find ourselves in today then, if alcohol will finish at 1900 hours on any day of the week if there is no event? Why were we not able to agree to 0700 hours to 1900 hours, 7 days a week, and then use the non-standard timings to allow extended hours on a set number of occasions? Why could we not agree to that?
We couldn't agree with it because there seemed to be I'm trying to be diplomatic here. There seemed to be a belief on the part of the licensing authority that this was going to be a vertical stand-up bar, and it's certainly not that. And this is what has been presented through the whole lot, and that's why we haven't been able to reach agreement. I might prefer not to come to a licensing hearing and to agree things. It's the way I've worked in the past for a number of years, but on this occasion, it was always the allegation that this was going to be a bar, a vertical stand-up drinking house. And we couldn't get past that.
So if I may confirm then, there's no event taking place, no cultural event, no birthday party, no christening, nothing like that at all. Monday to Sunday, alcohol stops at 1900 hours. Yes, is that correct?
Yes. I think we've already said this, Mr. Chairman.
So you just said that alcohol stops at 1900 hours when there's no events happening under the 20 events per year.
Yes, yeah. But
clause.
the norm is to apply for the maximum that you're likely to need to make it easier for the running of the premises. But given the obvious fear of the premises being a bar, which we say is totally unjustified, we will accept that.
Have you more questions?
Yes, please. Yes. So I do accept that Mr. Bartlett is representing Mr. and Mrs. Parger, or he's representing Edmund. But I would like to ask another question to Irina, if that is acceptable. Thank you. You may remember that I attended the premises on the 22nd of November when Mr. Bartlett wasn't present. To clarify, I was in that area for a completely separate reason, and Edmund came out to say hello. Sometime when I'm doing visits, I wear a bright orange jacket, so I think I stood out a bit and he recognised me. He invited me in and we had a chat. And this is the question because I want to make sure that we have definitely settled on this point. You said, Irina, that what you wanted really was on a Friday or Saturday if some customers were to come in, say, just before 7 o'clock, that you would have that flexibility to stay open and sell, you know, after 7 o'clock.
After 7 o'clock.
That you would like to be able to, so say a group of ladies came in for a celebration, it's coming up to 7 p.m. Rather than alcohol finishing at 7 p.m, you would have liked that flexibility to sell alcohol through to either 2300 or 2330, depending on the day of the week. Do you still stand by that? Is that still what you want to happen?
Mr. Chairman, this was an off-the-cuff conversation, and that was aspirational. It's what, ideally, Mrs. Parger would like to happen. But we've agreed to 20 events with the police, and that has superseded that. And it's exactly the point I make about things being lost in translation.
Okay, but if I get the ordinary sense of that communication correct, the that what you're saying is the answer to the question would be no, alcohol finishes at 1900 unless there is what you might call a pre-planned event that is probably by invitation only, I'm assuming, as part of the 20 events per year.
Yeah.
So somebody just coming in the scenario that was put kind of at 10 to 7 saying, oh, can I buy some alcohol and carry on drinking until 11 o'clock? That's precluded completely.
That is precluded, yeah. Aspirationally, it would be, yeah, that's great. People come in, we've got customers, we carry on. We've got 20 events. If they came in at let's say 7:15, they buy a bottle of wine. They have until 7:30 to consume that. Bearing in mind again, consumption is not a licensable event. Then they leave. They can't go on drinking until up to the end of the terminal hours.
And nor can they, as it were, say at 7:15, but I want to be part of your 20 events a year arrangement.
No. We would expect there to be reasonable notice.
Okay. So in terms of the 20 events a year, that's going to be planned ahead of time, and it won't be spur of the moment situation at all.
No, that's not anticipated at all.
Okay. Right. Does that answer the question? And have you any other questions?
No, thank you. No extra questions.
Okay. All right. Well, I think we finished that one section, which means that we can come on to the next section in the agenda is responsible authorities can raise their own objection if there is any. So, Mrs. Jennifer, it's over to you again now.
I'd like to spend a few minutes just going through with you how we've arrived at this position that we are in today. So if we could go right back to the beginning, to when the application was deposited with us. As part of our roles, we look at applications. And to remind you, and I know it's in your pack, the opening hours initially for this premises were from 7 in the morning to 12:30 midnight. It was described as a delightful cafe, and the expression of current operating hours of being 7 to 1900 hours. And that's quite important, isn't it? Because we've been hearing a lot about the 0700 to 1900 hours. And we're hearing that those hours are to continue, and that Edmund, the applicant, and his wife would like to be able to sell alcohol during those hours. It then goes on to say it is intended that alcohol should be available during normal operating hours, and the owners would like to occasionally put on cultural events. So you get that like initial description of the premises, and then naturally you proceed through the application, looking at the activities, the licensable activities that are being asked for, and you look at the operating schedule. And that's so important because that sets out how Edmund and his staff will promote the licensing objectives. Now, straight away I noticed, and you've identified this as well, that the hours are outside of our core hours. Ideally, and this does happen with some applications, that an applicant or their agent will straight away address the subject of our core hours, because some applications are indeed for outside of our core hours. Example could be a cinema or a restaurant. And they might say, well, yes, we are outside of your core hours, but because of the nature of our proposal, how we intend to operate, we don't think that there will be any adverse impact on the licensing objectives. Core hours form part of our licensing policy. They start at section 11 of our policy. I think it is set out in your bundle. But in that application, no mention of core hours, no mention of our licensing policy. Some applicants will put in there that they have considered, that they have read our policy, have considered what's in there, but don't think it's relevant. But no mention at all in this application of our core hours or our policy. Progressing through to the operating schedule, I don't think that that operating schedule was as good as it could have been. Now, I know I'm going slightly over old ground because through conversation, I know that some of the conditions are going to be sort of tightened up. But I have had this conversation with Mr. Bartlett about conditions, and they do need to be precise and they do need to be enforceable. And if you go through the operating schedule, one second. So, for instance, with the CCTV, the recordings, you know, will be available for viewing and downloading at any reasonable time. But what is a reasonable time? But I accept that, you know, we have you know discussed that. We struggled to get any sense of what occasional would be. Is occasional something that is every now and then? But I felt that it was important, and we did have conversations about how we were going to drill down to what exactly is occasional, because if we can't be certain on that, I don't know how we would ever, you know, enforce. I think that would be difficult. And then, of course, during cultural events, the doors will be supervised by a member of staff. Well, what member of staff? We know, and this is an important issue for us, will be supervised by a member of staff. So if you're going to have a person who is performing, I think it's called a guarding function, so somebody who's going to say, you're not coming in, or it's time for you to leave, so maybe where they might need to go hands-on, then, as Mr. Bartlett will know, that member of staff will need to be SIA authorised, approved, Security Industry Authority. You'll see them throughout many sort of town centres. And it goes on to say that that the door will be supervised by a member of staff who will request that guests leave quietly. I would have liked a little bit more detail there. So, to be clear, at no point did I ever say that SIA, so Security Industry Authority door staff, would need to be there for all events. But there's not even mention in the application of a risk assessment. So the applicant could have put in there that we recognise that door staff, not just anyone, you can't just pull somebody from the bar and say, go and look after the door. Somebody who is trained and authorised, that we've considered it. It is something that we'll do, but we'll do it by risk assessment. That detail came much later, but at least it has now appeared. But I would have liked to have seen a little bit more in the operating schedule about that, because remember, that's the steps that Edmund and his staff will take to promote the licensing objectives. And of course, we do need the fine-grained detail, and it's so important because we need to know how many door staff, what time, when, you know, when will they finish? But again, that detail can come from the risk assessment. And then we've got about challenge 25. So that's going to be their age verification policy, which is good. Doesn't say in here about what types of identification would be acceptable. That's something that I would typically expect to see in an operating schedule. But again, we have that kind of detail has now emerged so that we do have a better understanding about what type of identification will be acceptable. Just going back to the public nuisance objective, I want to flag that I think we could have seen more. I think we will need more rather than just guests being asked to leave quietly, because at number 24, there are 24 Lower Bridge Street, there are 4 flats above that particular shop. So yes, it's good, and we do see it in operating schedules that customers will be asked to leave quietly, but notices may be required as well, reminding customers to leave quietly. And if we go back to the cultural events, Mr. Bartlett mentioned it, but it doesn't have any sort of money impact, but having a member of staff who will go outside and check regularly to make sure that the noise levels are acceptable. I know that nobody is here from environmental health, that they haven't put a representation in, but of course that doesn't stop me as a licensing enforcement officer, as one of the responsible authorities, from flagging today that there is residential amenity nearby, and that could be impacted. We're talking about live and recorded music. At the moment, if you think about it, the premises is dormant from, what, 1900 hours? With the live recorded music, that could have an impact. So I think there would need to be closer attention to the outside area. Going through the application, there's no mention at all of the outside area. So when I arrived, when I did my visit, there were a small number of tables and chairs in situ. And I know that customers like to use that space. When an applicant is submitting their application and there's a box about describing the premises, it does say quite clearly that if the intention is to sell alcohol for consumption off the premises and you intend to provide an area for that consumption, that should be mentioned in your application. So you should describe what that area is and its location to the premises. That was missing from the application as well. We obviously do our research before we go out. I don't think it's in use at the moment, but I did note that the cafe is on Deliveroo. I don't think they're accepting orders at the moment, but we have heard that the off sales were added purely for consumption in that outside area rather than for deliveries. Why am I mentioning it? Well, revised guidance says that if a premises want to offer or intending to offer alcohol, an alcohol delivery service, they should mention it in their application. But from what I can glean, off sales are for that outside area only.
I might be able to assist in this if you will allow me.
Sorry, have you finished, Mrs. Geneva?
I'll
You just want to, can you hold it until she's
yeah,
finished?
of course, yes.
Yeah. Carry on.
Thread. Yes, so I think we've bottomed out that the off sales are for that outside area only, rather than there being an alcohol delivery service. So yes, I mean, for me, there's some of the issues with the application. You know, to be clear, we do get applications, and by the time you finish the 28-day consultation period, you have sort of garnered more, you know, more information. So it is a process. It was actually, no, I'll talk about the blue notice next, and the explanatory notice. Could I have the pack back, please, Mr. Bartlett? I'll keep this brief. If you could look at page 31 and 32 of your bundle. So just going back to what I said at the start about the opening hours, sort of from 7 in the morning till midnight. When I checked the blue notice, late night refreshment wasn't on there. That was a concern for me, because late night refreshment was requested in the application. What we want to see is the activities that are requested in the application correspond with the blue notice and with the newspaper advertisement. But late night refreshment was missing. Now the knock-on for Edmund would be that come 2300 hours, so this was before we'd agreed to reduce the hours, to curtail the hours slightly, that come 2300 hours, the cafe, as it's described, wouldn't have been able to sell hot food or a hot drink. So if the hours hadn't been amended, then yes, Mr. Bartlett is right. I was worried that the premises could be more bar than cafe, because what would happen between 2300 hours and 1 minute past 12? This was before the application was changed. They wouldn't have been able to sell any hot food or any alcohol. Any hot food or hot drink. Right next to, or below the blue notice in the same colour, was an explanatory notice saying the normal operating of the premises will remain as 0700 to 1900 hours on any day. It is intended to provide limited cultural events that may include the provision of live music appropriate to the nature of the event. Talks about the extended hours are applied for because there's a restriction on the number of temporary event notices that can apply, and then it's not intended that the provision of such events should be daily or even weekly occurrences. Now, straight away, we had some conflict, because when I read that blue notice and the explanatory notice, the impression that I was given, that I got from looking at those notices, is that alcohol would be until 1900 hours each day. The premises would close, except when there were going to be these occasional cultural events. During the visit, I asked what occasionally would amount to, and Irina, I don't know if Irina remembers, but her answer certainly wasn't daily or even a weekly occurrence. It was going to be more frequent. So that's why it was important that we drilled down into, you know, what occasional actually is. In terms of the 20, these 20 events, that was my suggestion. It wasn't the police. The police didn't attend. The police didn't meet with the applicant. I believe I was the only person that went out. I arrived at 20 because at that time, this was my rationale, at that time, the temporary event notices that were permitted were 20. They're not anymore now. We're back into 2024 and it's come back down to 15. But it was 20 and I was trying to be reasonable. And I thought, well, that might be, you know, a suitable figure. I also wanted to go a little bit further in that how do we capture these events? How do we keep track of how many there are? And again, there was some difficulty in agreeing on a bound book being kept at the premises. There was some difficulty about whether or not that was appropriate, whether or not it was, whether, you know, it was suggested that I must really mistrust the applicant to suggest that. But if we do a visit and there's a cultural event taking place, how do I know? How do I know how many there have been in that calendar year? To me, it made sense to have a bound book, to keep a note of those events. Oh, thank you. So we just couldn't agree, and that's why, you know, we're here today. I wanted alcohol to finish at 1900 hours. I didn't want the times on that premises license to say for activities 07 to 2300 or 07 to 2330, depending on the day of the week. Instead, I wanted 07 to 1900 hours and then use the non-standard timings, that box, use that facility to capture the 20 events. And same with the opening hours, we'd have to have the non-standard timings there as well. Otherwise, I would be worried that come quarter to seven, that group of ladies that come in, that because the license says 2300 or 2330 hours, that, I don't know, maybe it's through some confusion, we could see alcohol routinely being sold, regardless of whether an event is on. I mean, in terms of the licence and objectives, I am concerned by public nuisance. Our policy, our hours policy, and I think it's at 11 point, I did make a note. It's under 11.0 hours. And then further down, it talks about...
Which page are you on, sorry?
1 second.
Is this a policy you're quoting? What are you quoting at the moment?
Our policy, our licensing policy. Ah, yes, sorry, here we go. And then I'm finished. So in terms of, public safety, public nuisance, 11.3, applications for hours outside the core hours set out below in this policy will be considered on their merits. And if you go to B, it says whether there is residential accommodation in the proximity of the premises that would be likely to be adversely affected by the premises being open or carrying on operations at the hours proposed. So the live, recorded music with people living quite so close, I think that would require management beyond just asking people to leave quietly. I suppose if you have got a door staff on, then as part of their role, they would routinely say, shh, or go away, don't sort of linger outside here, and they could keep an eye on the noise levels as well. But certainly didn't ask for SIA every day, and I think a risk assessment would be sensible. So just to finish, what I'd like to see is the reason why, by the way, I didn't have any objection to the 0700 to when our core hours start, is because I felt the risk would probably come later on, when the premises is open for the extended hours for the cultural events. And of course we have agreed to bring the core hours, to bring the hours in line with our core hours that has been agreed now. Thank you.
Okay, thank you for that. This is your opportunity, Mr. Bartlett, to ask questions of Mrs. Geneva.
I haven't got many questions, actually, because the Deliveroo matter no longer exists, for the simple reason that Deliveroo were charging far too much commission, and it wasn't cost effective for the parties to continue. So there's no delivery of food, no delivery of alcohol. That's it on that. With regards to the conditions on the number of events, we can see here today that we rely greatly on IT. And as I said to you earlier on, I've produced a nice simple spreadsheet that will record the events. If we want a bound book, we can get one of those from Smith's. It's called a diary. And they can be recorded on there. But for the purposes of the police, the licensing officers, trading standards officers, we believe that the IT system is better. With regards to incident logs, when you open a cell within the spreadsheet, it expands. So you can put as much detail as you like in there. Product refusals. It calls for name and address or description of the person refused. So I think whilst I understand the old-fashioned look that we all used to know of, you have a bound book, one for incidents, one for training, one for events, one for refusals, but they get lost and they get altered. There's nothing to say, of course, that spreadsheet won't get altered, but you're looking for management sign-off on all of the spreadsheet. So from that side of it, we're happy with IT.
Yeah, I guess the question you're asking of the licensing enforcement officer is that therefore sufficient for a log? So is that sufficient for a log?
Speaking from experience, when you go to a premises and you want to check, say, their refusals book, or you want to know how many events of a certain type they've had, it's just so easy to just pick up a book from behind the bar or the counter and say, here you go. I'm all for IT and modern times. Of course I am. We use computers all the time, but a bound book, I just think it's so sort of straightforward. I'd rather see that. That was incidentally what I offered as a condition last Friday morning to Mr. Bartlett, but I didn't receive a reply to.
Okay, any more questions of the licensing?
Yeah, does the officer accept that much of what she said now relates to before discussions? She's made a great importance of the operating schedule, but it's not unusual to discuss the operating schedule with responsible authorities and to work out, as we have with the police, the conditions which they would like to see on the licence. So will she accept that, it's an ongoing process?
I think I just wanted to explain how we ended up having to convene the licensing subcommittee for this matter today. The application, as it was presented, I wanted to go through that with you because I felt it was poor. I felt it could have been better. Yes, Mr. Bartlett's right. We did make progress once we started talking, but we have had during that 28-day period a lot of disagreements around conditions and about what is appropriate, what's necessary. Do we really need to go as far as determining what occasionally is? Yes, we do. And I just think it could have been a better application.
Okay, Mr. Bartlett, any more questions of Ms. Juniper? Otherwise, I'd like to sort out some clarifications from my own mind.
Yeah, I'll carry on, sir, and hopefully it'll come out in it.
Okay. So, in terms of clarifications in my own mind, I mean, mention was made that there were some more residential units than I was aware of. Can you actually describe where they are in relation to the cafe?
So let's pretend that we are outside the cafe and we're facing the premises. You may have noted that to your left there is a premises called Canterbury Corner shop store on that corner. There's you may remember there was like a little, actually you were probably looking at the cafe, but there's like a recess, a little sort of covered area, and that is a door that leads.
There are some flats above the corner shop there.
Yes.
Which is a grocery shop and stuff like that, basically. Okay, so there are some flats there. I was unaware of that, so thank you for clarifying that. I think the other bit of clarification that comes that seems to be important in terms of one of your concerns, I believe, is that kind of changeover moment between the ordinary operating hours finishing at 7 o'clock, and if you're having an event, is there any space between 7 o'clock and the starting time of the event? So the issue becomes, if somebody turns up at 5 to 7, are they coming for normal operating hours, as it were, or are they a person that's arriving for the event, which is that night? And therefore, how do the staff distinguish between who's coming to one of the planned activities and who's just coming in off the street? Maybe that might help, actually, I think.
I think there would be a natural pause between the two because you'd be setting up whatever the event was.
Right.
And that would be the natural pause between the event where the person who's coming at 5 to 7, say, is told there is a private party on and requested to leave.
Okay. So generally speaking, people would be leaving at 7:30.
There's a possibility of them leaving at 7:30. Yes, that would be true with the drinking up time.
Yes. So the 20 events are likely to only start.
I would think around about 7:30 at the very earliest.
Okay. All right. And that therefore gives staff the possibility of distinguishing somebody coming in off the streets and somebody coming from.
I think it's a simple question. Are you here for the event, sir? No. Well, I'm very sorry, but there's a private event on.
Okay.
We like your custom, but please drink up.
All right. So it's very clear that these 20 events are private events, invitation only type thing.
That is the way we are looking at it. We don't even think it's going to get anywhere near 20.
Yeah, sure.
You know, it's Irina has just said to me, 5 to 10 would probably be in the first year, the type of events we'd be looking at. And as I said to you earlier on, it's a practice in applying for a license to apply for the maximum hours you are possibly going to need, and then moderating them as things go on.
All right. Okay, those are the clarifications that I needed myself. Where we're at in the process now is, Mr. Bartlett, you've got the opportunity, we're moving on, you've got an opportunity to summarise the application, and then after that, the committee will retire and consider it. So would you like to summarise?
Yes, Mr. Chairman. As I said earlier, Canterbury City Council has not deemed it appropriate for a special policy. The result of that is that there is an assumption that the licence will be issued subject to the 182 guidance, your policy, and the conditions. We say that all conditions have to be proportionate necessary. We understand that Canterbury's got more than its fair share of licensed premises. Personal view is that that's probably a case for making a special policy, but that's not for me. There is a Wetherspoons opposite and Cousins, and they bring their own particular brand of disturbance, shall we say. Amelis doesn't fall within that remit. Today, I saw the youngest clientele that I've seen there in all the times that I've visited. It's mainly for people like, as I said, mums with kids, middle-aged people. I would be quite happy to take my 94-year-old mum there. And that is the type of premises that it is. It's not a bar. There's no intention of it being a bar. And so it's going to be a cafe that does occasional events. With that in mind, we have agreed the police conditions. I've explained to you that the early morning condition is purely to negate the offence of offering for sale. I don't think it's appropriate that we curtain things off or remove things because the Act isn't meant to be onerous. It's meant to be a light touch administration. That was made clear in all the debates in Parliament and in the Act itself and in the guidance. It's meant to be light touch. That's why reviews were built into it. If the licensee doesn't actively promote the licensing objective, anybody can call for a review. There used to be only interested parties within, the figure was around about 150, but now it's throughout the area. So anybody can call for a review if they think the licensing objectives are not being promoted. I think my clients have been more than accommodating. And then what we would ask is that you can, obviously the mandatory conditions have got to go on there. Not that we think any of them will truly apply to families. There's the police agreed conditions, and they were a amalgamation of the conditions that Sue went for and the police licensing officer. Although Sue has expressed concern about noise, and that's understandable, the EPO hasn't sought to make representation. They are the ones who actually are trained, and has the experience in assessing whether or not there's going to be a major problem. And we would say that goes a long way to saying, you know, this isn't going to be a problem. This isn't going to breach the licensing objectives. Added to that, the fact that I will be providing training manuals for the staff. It's based on, as I say, trading standards tutoring package. So it's been accepted by licensing authorities throughout the UK. I will ensure that Challenge 25 is obtained and set up within the guidelines, the photo IDs or what have you. And I will keep in contact with the Pargers to ensure they have no problems. The application is before you in its amended form, and I would ask that you approve it, but only with such conditions are absolutely necessary to promote their licensing objectives.
Thank you, Mr. Bartlett. So this is the moment in which we'll adjourn and consider our decision. And let me just hold on a moment. We're going to adjourn for half an hour. So basically, we'll come back and announce our decision at let's make it 10 to 1. Okay. Sorry. Yes.
Yes, just no, I'm gonna say something just about the shop. Maybe you didn't come before or you didn't know. My name is Irina. I came 4 years ago with my husband and our twins with luggage, nothing else. And we tried to fix it something for their future. The reason that we try now to have the license is because the shop is not, everything is too expensive. And we haven't, we spent too many hours there, me and my husband, sorry.
It's okay.
And we try to find the choice to go through a way. We try to pay everything, to be correct with the council, to be current with every tax with the government, to be current with my sister, because only she worked there for some hour and help us. And to try to give to community, to the Canterbury community, our culture. I'm Albanian, but I grew up in Greece, and my daughter are born in Greece. We have very, very enjoyed life, or good life, good music. We are people, are kind and smiling people. I would like to give to everybody that we have inside us. I have behind me a big lawn, very big lawn, nobody knows. But me and my husband try every day. I'm so sorry. Just that's it. Thank you.
Mrs. Parcher, that's fine. Thank you very much for putting it in your own words. Thank you very much for that. So we're going to adjourn now, and we'll come back in at 10 to 1. Okay? Okay, thanks for giving us a little bit longer than we predicted. So apologies for being a bit late back. And I can see everybody's feeling chilly. So let's try to get on with it. Anyways, I'm pleased to say that we are going to agree to the granting of a premises licence for the purposes outlined. It is going to be subject to some conditions after discussion, and most of these conditions, I think, have actually been thrashed out and agreed beforehand. So I'm not going to remember all the detail of the conditions, although we've gone through them in particular order. So I'm going to ask Mr. Key to describe the conditions associated with the granting of the licence. Okay, so Mr. Key.
Thank you. Just to record that the subcommittee's taken account of the agenda report pack that was published in advance and of all the oral representations, submissions and points made at this hearing, and taken account of the Licensing Act, the licensing objectives, the statutory guidance, Crime and Disorder Act, our own statement of licensing policy, and the public sector equality duty. The application itself was in respect of late night refreshment, alcohol on and off sales, and regulated entertainment, namely live music, recorded music, performance of dance, and anything similar to live music, recorded music, and performance of dance. And that was for certain hours in the original application. I should just point out that late night refreshment wasn't included in the blue notice, and hence that application, that aspect isn't granted. I should also point out that live music isn't licensable in certain circumstances. For example, on a premises that has a premises license between 8 in the morning and 11 p.m. And similarly with recorded music, there's an exemption that applies in similar circumstances. For the licensable activities, apart from late night refreshment that I referred to, and taking account of what was said about live and recorded music, the premises license granted today is for standard hours, all licensable activities, those mentioned by the applicant's agent, from 7 in the morning to 1900 hours, with noting that it opens at 7 and closes half an hour after the 7 p.m, that's 7:30 close. Those are the standard hours. Then there are non-standard hours, which are covered by later conditions for cultural special events. And those hours are, as stated by the agent during this hearing, 7 in the morning to Monday to Thursday and Sunday, 11 p.m, and Friday and Saturday, 23:30 hours, closing half an hour later. And just to make the point that off sales finish always at 7, which is the standard hours, and there's a condition relating to the fact that off sales are only for consumption at the front of the premises in accordance with the pavement licence. So as to the actual conditions, these are as set out on page 33, as varied slightly by the licensing officer's conditions on page 44, and as varied during the hearing. So condition 1, which is about hours, is superseded by what I've said about hours. Condition 2, which is about 20 events a year, is governed by what's said at page 44, and so 44 has 2 conditions, main conditions. Does the licensing officer have the right pagination for this? It's just the final page of her submissions. So the premises, it's for standard, it's for 20 special or cultural events a year, and that's for each 12 months, not for the first 12 months, for each 12-month period, calendar year, and an occasion is not a weekend, it's a single day with those non-standard timings. And then the subcommittee want a written record of this kept in a bound book. Which can be inspected in the way described on page 44. Then the condition 3 on page 33, CCTV applies. It's to be provided forthwith, promptly upon request. Otherwise, following that, the training requirement in condition 4 is there, 2 paragraphs. The logbook in condition 5 should be made available to the same people as the CCTV. Condition 6, off sales, as mentioned, for consumption in the pavement area. Condition 7, alcohol to be supplied on the premises by a waiter or waitress service. Condition 8, deleted. Condition 9 applies the risk assessment about the need for SIA staff, and condition 10 applies. So those are the conditions that will be added to those hours, and that's the decision. I just explained to the parties we're obliged to refer to the fact there's a right of appeal, section 181, schedule 5, very strict 21-day limit to the magistrates, not to the council. Thank you, Chair.
Okay, in respect of concluding that, we just wished Mrs. Parger to have every success in your endeavour in your business. Okay, there's...
Can I just ask for one clarification?
Okay.
It's only for my own mind. The CCTV, now obviously, as I said earlier, the police could ring in and say, we want your CCTV. But when will the actual request be formalised? Will it be when they turn up at the scene? And that's only an administrative point, so that Mr. and Mrs. Parger don't get into any bother.
Mr. Key, have you...
I'd said, I'd read out forthwith, promptly, and I think that contemplates attendance by the person requesting at the premises, rather than the applicant having to drive to a police station with it.
Right, yes, okay. Okay, so we're clear about that. It's they turn up and ask for it on the premises. Okay, thank you. Okay, well, that concludes that business. On our agenda, there's any other urgent business, and I can announce there is no any other urgent business. So thank you, everybody, for their contributions and helping the subcommittee reach a decision. And I wish you a warm trip back to your place of work or home or whatever you're doing next. Okay, bye.